Hello, good evening, everyone. As I said from my intro, we have another opportunity to continue this legal hour program. Tonight, I'm going to look at a special topic in immigration. I'll be looking at entry clearance visas. Specifically, I'll be looking at how parents who are living abroad can rely on their children who are either here with the other parent to apply to join them in the UK. Now, so I'm going to look at it specifically by looking at all the requirements that they need to satisfy. Many are those who, because of financial requirements under the Appendix FM, it's been almost impossible for them to come to the UK to play a role in their children's life or in their child's life. Tonight I'm going to uncover some of the areas that they can rely upon without necessarily meeting some of these requirements, which have become impediment for them to come here and play a role in those children's life. Of course, last week we looked at how parents who are not, let's say, biological parents can rely on children that are not their biological children, just by virtue of the fact that they play a role in their lives, they are able to also apply for leave to remain. And I'm looking at this almost similar topic in terms of people who are less than biological parents and are living abroad and they want to apply for entry clearance to join either a child or children here in the UK who are living with the other parent or living with a family member here. That's what I'm going to do tonight. So I want to urge you to obviously to share the video and also invite your friends to join us tonight. I want this topic to be very interactive. If you have any legal question, this is an opportunity for you to participate and ask those questions. As I always say, I am not a medical doctor because I cannot give you any diagnosis of whatever illness you are suffering from. I am not a pharmacist to prescribe medication for treatment. I am not a family mediator to help you to build your relationship. But there is one thing that I'm very confident of, which is the fact that I know the law in the area that I practice. And tonight I am here to give free legal advice. This is why it is an opportune moment for you to join me and have free legal advice. Yes, so as I do always, I'm going to go on short commercial break to allow viewers to have opportunity to get themselves prepared for this topic, and also take advantage to share this show with their friends and family members. And when I come back after this short commercial break, I'll take my time to look at the topic by dissecting all the areas that matters, that allows one to rely on a child living in the UK to join them here by obtaining settlement visa on that basis. So please don't go away. Hello, thank you for your patience. Uh, if you have just joined me tonight, I'm looking at immigration. Uh, if you haven't watched the show I did on the budget, I urge you to go and watch it and listen to it because it explains most of the stuff that a lot of people are confused about. So I want to urge you, if you haven't watched that topic on the mini budget, it's important that you go back to it and watch it again because there's a lot of stuff in there that will assist most of you to understand your tax threshold. If you want to buy a house, whether or not you are liable to pay stamp duty, land tax and stamp duty. If you're a business person or owns businesses, it will also help you to understand the threshold for your corporation tax. And those of you who are on universal credit, sadly, there isn't much there for you. But I want to urge you to stay, watch it or listen to what I said in that mini budget when I did it last week. But tonight I'm looking at immigration. Obviously, those of you who have been following us, you would have been aware that, or you'd have familiar that last week we looked at how non-biological parents who are living here and playing a role in children's life can rely on the fact that they are playing that essential role in that child's life to make an application for leave to remain. And I took my time to explain all this to viewers. But tonight I'm not looking at in-country applications. In fact, I'm looking at entry clearance application. When we say entry clearance applications, we are looking at those who are making application from abroad. So you might be from Nigeria, Ghana, America, any part of, in fact, even any of the member states in the European Union, because the UK is no longer a member state of the European Union. So you could be making application from any of these member states. So this topic is for those of you who are living abroad and want to rely on the fact that maybe your girlfriend came to any of these countries, had a baby with you, had a child, and the child is living here, and you want to be closer to your child. There was a time that somebody called me from Germany and he said to me, "Lawyer, is there any way that I can be able to come to the UK?" I was in a relationship with somebody in Ghana. He moved here. We have 2 kids together. The kids are here and I am living somewhere in Germany and I want to be closer to my children. But I don't know how to do it because I am no longer in a relationship with my girlfriend and therefore he doesn't want to assist me. However, I have the best interests of these children and therefore I want to come closer to them. I want to live in the country where he's living so that I can play an essential role in their life. Now this topic is for that gentleman who found himself in this difficult conundrum where he wants to play a role in his children's life, but he is not in a relationship with a girlfriend who was unwilling to facilitate that process to take place. So tonight I'm looking at those of you who are living abroad and want to join your children from here. There are some of you who also have children with either a man or woman living in this country. The relationship has broken down irretrievably. That woman is probably even married to someone else. But you still have a child. There is a child between the 2 of you. So you are not coming here as a spouse. You are only coming here to join your child, to play a role in that child's life. So that's the second example. There are many of you, for example, who, I remember a gentleman who once called me and said that I was in a relationship with someone here. We had 2 kids. Something happened, and I was removed and sent to Ghana. Honestly, I still don't understand why he was sent to Ghana, being a father of British children. But hey, these things do happen because people don't know their right. And the gentleman has now found himself in Ghana. And though the girlfriend would have wished to assist him to come back here, but sadly, he's on universal credit. He's not working. And even if he's working on part-time basis, so he doesn't meet the financial requirement, which most of you are familiar with, that you bring a spouse or a partner from abroad to join you here. You need to show that you're earning at least minimum of 18,600 per annum. And he is not earning that amount of money. So this gentleman is stuck in Ghana. He cannot come here. But this particular topic is an area of the law, the immigration rules, that allows him to join these children. And from my interaction with him, even the woman have taken the children there a couple of times just for them to see their father. But the father can't come here because of the immigration rules. But it is not just because sometimes people complain a lot about some of these immigration rules. But the fact is that there are various rules. It's up to you to understand some of these requirements. So normally when we are interacting with clients or potential clients, we assess the entire circumstances to know where to fit them. And that's why sometimes people think that we can do the impossible. It's just of the understanding of the law. So tonight I am taking my time, obviously, to explain this area of the law. As I do always, I'm going to give viewers opportunity to ask questions at the end of my submission. So as I said, if you look at the screen, you see the topic, which quietly reads that applying for settlement from abroad to join your child in the UK. So if you want to apply for settlement, which means that you are coming to stay here permanently to join your child in the UK, then in this case, the starting point is looking at who a child is and who this applicant is. So if you want to apply from abroad to join your child in the UK, then that particular applicant must be a parent, and this time he has to be a biological parent. I know I did a topic about non-biological parents being able to make application for leave to remain because they are playing an essential role in that child's life, who's, for example, one of the parents is no longer playing that essential role, and therefore that person has stepped in the shoes of the absent parent. But tonight I'm looking at the biological parent who is living abroad and want to come to the UK to join the child, not necessarily be in a relationship with the mother or the father whom the child is living with in the UK. Or in fact, even if the child is living with another family member. So that's what I'm looking at. So the starting point is to look at who a child is and what child will enable a parent to make application to join them in the UK. Obviously, when we say a child under the immigration rules, I know under the EU law, it's up to the age of 21, but under the immigration rules, we mean someone who is less than the age of 18. So in this case, if you look at the immigration rules, the definition of a child is quite clear, which is someone who is under the age of 18. But again, it is not every child that someone can apply for settlement to join them in the UK, because they need to have immigration status requirement, or that child needs to satisfy immigration status requirement. And this is where the challenge is. First, that child must either be a British, which means that one of the parents either had indefinite leave to remain or was a British when the child was born, and therefore the child was born automatic British. Or these days, children who have been born here, who have lived here for 7 years or more, who can then apply for indefinite leave to remain. And so the second point is that that child needs to have indefinite leave to remain. And the third category is a child who have limited leave to remain granted under the Appendix EU. So in this case, if, for example, you came here as an adult dependent of your mother or father under the EU settlement scheme, or you are here for whatever reason, you have limited leave to remain under the EU, granted under the EU, and then you then had a child with another person who is living abroad, because that child have limited leave to remain granted under the Appendix EU, that father or mother living abroad can then apply to join them here. So here you find out that the definition excludes children who have limited leave to remain, except limited leave to remain granted under the Appendix EU. So that's the category of children that we can consider that will be eligible for those parents to join them in the UK. But having said that, you also realize that there are numerous requirements that the applicant who is coming to join that child in the UK needs to satisfy. So having considered the definition of a child and the immigration status requirement of that child to enable that parent who is living abroad to apply and come and join them in the UK, then there are other requirements that the applicant, which is in this case the parent who is applying from abroad, needs to satisfy. Now, in most cases, it is an essential requirement that that parent, in this case biological parent, applying from abroad, relying on that child living in the UK, needs to satisfy an essential requirement, either being someone who has sole responsibility towards that child, or have access right to that child. So here I need to take my time to explain it. So you realize that for one to have sole responsibility of that child, it means that perhaps even if the parent who is living in the UK is here with the child, she might not necessarily play any essential role in that child's life. So for example, that parent who lives in the UK might have abandoned the child or left it in the care of one of the grandparents. And whoever is living abroad has the sole responsibility, because she is the one constantly in touch of that child, ensuring that the child go to school, making sure that if there is financial remittance, she sends funds for the upkeep of the child. Even if she's living abroad and is able to apply for visit visa, he visits the child on his birthdays or another special occasions. He comes around to play a role in that child's life. And the other parent who is living here is not playing any role in that child's life. So under those circumstances, it means that the child living here is being catered for indirectly through the carer by the parent living abroad. So that parent living abroad has what we call sole responsibility. And this definition is established in the case of T.D. Yemen, which is an old case law. So that's one of the initial requirements that the parent seeking to make application from abroad to join that child living here, either because he has indefinite leave to remain or as a British to join, needs to satisfy. The other essential requirement is that parent living abroad must have what they call direct access or contact with the child. So in this case, there might have been a court order with a child arrangement order in place, enabling that parent abroad. Maybe I know one of the cases that I was involved with, the parents lived abroad and he has child arrangement order. So maybe once a year she comes purposely to the UK to interact with the child, or twice a year. That child arrangement order is in place. It's a unique child arrangement order. He doesn't live here, but he wants to play a role in the child's life. And sometimes when he's coming, the mother doesn't want provide access for the parent coming from abroad. And in most cases, the case has been taken back to the court for the court to deal with it. And at some point, I was advising that if you continue to behave in this manner, then this behavior could be considered as contempt of court, because that father has the right, which has been granted by the court, to be involved in this child's life. So that's one. So this particular parent I'm just describing can rely on this child and make application to come to the UK and live here just because he has that child arrangement order in place and meeting other essential requirements. So that's one example. It could also be some form of parental agreement put in place between both parents. So the parent living here might enter into an arrangement, which is what they call parental agreement, that once a year perhaps I will come to abroad and bring the child for you to see the child, or maybe twice a year. If, for example, you are buying ticket for the child, then I will make sure that that child comes to wherever you are so that you can have that contact. Or if, for example, again, you come once a year, this time it is not a court order, but it is a mutual agreement between both parents that the one living abroad should have a contact or direct access to that child. So that's one of the requirement, which is the parental relationship requirement that that person needs to satisfy if you are seeking to make application to join a child from abroad. So I have obviously explained the fact that there has to be a child who is under the age of 18. There have to be a parental relationship where that person have access to that child, either through court order or parental agreement. But the third point here is that parent who is coming from abroad needs to satisfy maintenance requirement. This time it is not the financial requirement. I've said that the financial requirement most time people get confused, only applies when one is seeking to join a spouse or a partner in the UK. However, that parent coming from abroad to join a child in the UK so that they will be able to attain their settlement, they need to meet what they call maintenance requirement. This maintenance requirements is in two folds, which is to ensure that whenever they are coming to live here, they have sufficient funds for their maintenance, such that they will not be a recourse to public fund. And secondly, within that same maintenance, they should be able to demonstrate that they have sufficient accommodation. So in this case, wherever they have arranged to come and live, that place should not be overcrowded if they were to join or to come and live in that household unit, or whatever it is, whether it is house owned by them and they are living abroad, they want to move back in, they should ensure that when they come back, that household will not be overcrowded. So that is the maintenance requirement, obviously, that person needs to satisfy. Having said that, this is another area where if one is not exempted, then that person needs to meet the English language requirement. Now, this English language requirement, it is normally an A1 European framework test that one has to undertake and satisfy that they can speak and listen. It's just two components. It's not like the B1, which is reading, listening, writing, and speaking. This one is just speaking and listening. So it's very, very low-level English, and that person needs to satisfy that requirement. So to paraphrase or to summarize those requirements, we realize that you need to establish that you are a parent of a child, and secondly, that child is under the age of 18, and the child falls within any of these three categories, which is either a British, a child with indefinite leave to remain, or a child with limited leave to remain issued under the Appendix EU of the immigration rules. One also needs to show that either they have sole responsibility, which I have already explained what it means for a parent to have sole responsibility, and one also needs to show that in the absence of having sole responsibility, that is, if they don't have sole responsibility because the other parent is here playing role in a child's life, for example, living with that child, then it means that at this point, because the parent is living with that child, responsibility is automatically shared because one of the parents is playing a role in that child's life by living with the child. So at this point, two things could happen. Either there is a court order, which is child arrangement order in place, or there is mutual agreement between the parents where there is what they call parental agreement signed and witnessed by the parents. So under those circumstances, it sets out what role the parent abroad will be playing in the child's life in terms of how often they will see that child and what they should do. This is something that could be put in place. And fourthly, they also need to meet this maintenance requirement, which is to show that they have sufficient money or funds that when they travel all the way from abroad to live in the UK, they are not going to be a burden on the state. And they also have accommodation where they will live without recourse to public fund, again being a burden on the state. And that place will not be, for example, overcrowded because of that parent traveling from abroad to come and live in that household. And finally, they also need to meet the English language requirement. So you see that with what I've explained so far, if you're a parent living abroad and whoever is the mother or the father of that child does not meet the financial requirement, yet you want to come to the UK to play a role in that child's life, and then even if the parent who is living here is unwilling to do that, you have the right to have a court order in place, which is an arrangement order, and that in itself gives you the opportunity for you to rely upon it and apply to come to the UK on the basis that you are a parent of that child who falls within these three categories that I have already explained. So it is not impossible that if one does not meet a financial requirement, which is something that has become an impediment to most people joining their spouses here. And there are those who also have had kids with other parents and are married, and because of that, they don't even want this other parent living abroad to be involved in their life because they have moved on. The answer is that you don't need this woman to facilitate your entry to the UK, because you can simply rely on that child without any support from the other parent, who is either the mother or the father of that child, in order for you to be able to apply for your settlement visa to come to the UK. So tonight, it's been a privilege for me to obviously look at this area of the law. At this point, I'm going to obviously advertise the office who is sponsoring me to run this show tonight. And for those of you who have joined us tonight, I have Ernest Nakari, I have Honest Prick, I have Sophia Song, who is also watching tonight, I have Kenechi, Augustine Piasa, I have Honorable Isaac Osei, Onyi Inspire, who is also watching tonight, D. Ajirem, Ivonate, I think Ivonate is all the way in America, who is also watching tonight. I have Diana Ajaman, Akua Sawa, and Highly Favored Pesla, who have joined us tonight. At this point, I am going to take few moments to advertise our sponsor, who has made it possible for this free advice to be given to the public. So this program is run every Tuesday in English, and this time Wednesday the same time in Twi language for all the Ghanaians in the diaspora. And the program is proudly sponsored by CITI Law Solicitors. Now, CITI Law Solicitors is a firm which can be found in Barking. So if you want to visit us, you get to the Barking station, you just come out of the station and turn right. You walk for literally 30 seconds, and then you find a zebra crossing. You turn right again, walk for just less than 2 minutes. There's a traffic light, and on your right hand side of that traffic light, there's a building called Barking Enterprise Center. You'll find CITI Law Solicitors in Unit 112 and 122, Barking Enterprise Center, 50 Cambridge Road, Barking. IG11 8FJ. If you want to contact us, it's 020 33 55 0782. This is the office contact number, 020 33 55 0782. What areas of law do we specialize in? Now, CITI Law Solicitors, we specialize in numerous areas of the law. Tonight, I have been obviously taking the moment to explain how one can apply for settlement as a parent living abroad, relying on the child who is living in the UK without the support from either the mother or the father or the other parent who is living in the UK. This is part of the immigration law. So we specialize in immigration law. Those of you who have had the opportunity to use our service, I'm sure you can testify that we do our best to get results for our clients. So we specialize in immigration, nationality law, and asylum law. So if you have any immigration matter that wants us to deal with it, if it's this topic that I've discussed tonight, if it fits, I know there are many of you out there who want to join your kids in the UK, and perhaps have never been aware that there is a route under the immigration rules that allows you as a parent living abroad to join your child in the UK. Tonight, I have taken my time to explain that to you. So that's the immigration area of the law that we specialize in. Employment law, if you have been dismissed unfairly, I always say that for you to be able to have the statutory right of unfair dismissal, you should have been employed by the employer for 2 years or more. However, if you have received unfavorable treatment, which is discrimination at the workplace or breach of the Equality Act, being a pregnant or a mother on maternity leave, or you have been unfairly been made redundant, if, for example, you have suffered bullying and harassment and victimization at the workplace. These are all areas of the law, under the employment law, that we can assist you to obtain some form of compensation if you have suffered any of these breaches in the hands of the employer. Family law. We are family law accredited. I always repeat it here that the distinction between a solicitor firm and family law accredited firm is because when one is family law accredited, it means that we are the peak of the practice. So if you want to have child arrangement order in place, for example, in order for you to rely on it to join your child from abroad and play a role in that child's life, we are here to assist you. If you have suffered domestic abuse and you want to make application for occupation order or non-molestation order, if there is an unfortunate circumstance where you're going through divorce and you want us to represent you, we are also here to assist you. Personal injury and clinical negligence. If you ever had accident at the workplace that it was not your fault, we will also be willing to assist you to claim some form of compensation for you. If you were involved in motor accidents or you've been knocked down by a runaway car, we are here to assist in cases of this nature. And interestingly, we do most of these cases on no fee basis. If we lose the case, we all lose together. If we win that case, it's only at that stage that we get a token of the share of that compensation. So don't be terrified of the solicitor's fee and fail to pursue the case. We can always assess the case. If there is merit, we'll take it up. Commercial dispute and civil litigation. In most cases, if someone is owing you and he doesn't want to pay, we'll be able to go after that person and possibly sue that person in the civil court to claim that money for you. If you have opened a business and you want to put in place partnership agreement or put in place shareholders agreement or directors agreement, any corporate matter that requires solicitors' assistance, again, we are willing to assist in those areas of the law. Housing, those of you who are being unlawfully evicted, who have living in houses this winter, there will be houses that will be mold all over the place, windows has fallen off, electricity and gas has become so expensive because of lack of double glazing. That house is so cold that you end up spending so much money. There have not been much maintenance. We can assist in those cases. So tonight it's been quite privileged to have you on this show tonight. On Thursday, I'm going to have this show again with MC Chaka, who is going to host this program in the Tree language. And obviously, I'm sure that most of you, as I explained from the beginning, will be able to rely on this route if it becomes necessary that you have to join your child in the UK and you are not receiving that support from the other parent who is living here with the child. There is always a way. So I want to thank all of you who have joined us tonight, and hopefully tomorrow, Wednesday, MC Chaka will be here to host the show wherein we have the tree section of the program. Thank you. God bless you.